Hi, on today's video podcast, I wanted to raise some interesting provisions on Assembly Bill 587 from the 2022 California legislative session. And the bill dealt with social media companies, and I thought it had two particularly intriguing provisions. It would add two sections to the California Business and Professions Code, essentially requiring a social media company to post their terms of service for each social media platform owned or operated by the company in a specified manner, subject to certain exceptions, of course. The bill also stated the intent of the legislature that a social media company that violates these provisions would be subject to meaningful remedies sufficient to induce compliance with their provisions, and also specify civil penalties that a company would be liable for if they violated the bill's provisions. And the AG or a city attorney could bring an action to enforce any violation. So the first intriguing provision is in section 1 of the bill. It would create the following uncodified language. It is the intent of the legislature that a social media company that violates this act shall be subject to meaningful remedies sufficient to induce compliance with this act. Now, this is merely a statement of legislative intent, but it's stated as if it's almost codified language. It uses the mandatory word shall as if it's imposing a duty upon a prosecutor to bring an action. And it uses an ambiguous term, meaningful remedies, without defining that phrase or that term. Moreover, the standard to be met is also without definition. It's sufficient to induce compliance. What do those mean? The second intriguing provision I found in some of the proposed codified language. It read in 22679 subdivision B, the remedies or penalties provided by this chapter are cumulative to each other and to any other remedies or penalties available under local, state, or federal law. Now, this language isn't unique because it's similar language that can be found in other codified sections around California's 29 different codes. What makes it intriguing to me is when it's read in conjunction with section 1 of the bill. And earlier in the bill, there's a $15,000 penalty for violating provisions of this new act. So based upon the language I just read, multiple financial penalties could be assessed against a social media company in trying to ensure compliance. In addition, there may be other local, state, or federal penalties, and those too can be assessed against the social media company for the same exact violation. And a court could potentially read section 1, the legislative intent language, as inducing even more penalties to assess in order to ensure that a social media company is quote unquote induced into compliance with the act.